Now back to the show. This is The Law Show on CL 650.
Welcome back to the program. Sterling Fox with you in studio. Gordon Maynard and Alex Stojcevic, partners with Maynard, Kisher, Stojcevic, immigration and citizenship lawyers in Vancouver, downtown at 1168 Hamilton Street and online at vancouverlaw.ca. We're talking family class immigration on the program today, a category that, as our guests have already informed us, has diminished somewhat in terms of numbers over the years as the government over time has seen fit to emphasize other categories or classes of immigrants to attract to Canada in addition to family class. But family class is and always must be a sponsored class, as we've already established. Right, Gordon?
Correct.
Okay, so, but before we get to sponsorships and wait times, and wait till you hear about this, friends, there's this category, because a lot of us are under the impression that as long as you're somehow related, my wife's second cousin by her third marriage is coming to town, let's sign him up. Well, we can't do that anymore, and in fact, over the years, as Alex and Gordon have pointed out, those criteria have shrunk to now, Alex, if you'll review those very quickly for us, the people who are sponsorable by Canadians.
So children from a previous marriage, children that are adopted by a Canadian couple, spouses, which includes common law spouses, as defined under the Immigration and Refugee Protection Act.
Okay.
Married spouses, this interesting category called conjugal partners, and effectively parents and grandparents.
And that's it.
That's pretty much it.
Not even brothers and sisters anymore.
There are very few situations where you can sponsor anyone else other than the list that I've given.
Right.
And we talked about that on the last show, the Lonely Canadian. There is the possibility of sponsoring someone where you have no one alive that is sponsorable, or if you've never been married, or your parents are dead. There's if you meet about 6 or 7 different criteria, then maybe you can sponsor one sibling.
Okay.
But that's about the only situation where you can.
Now, Gordon, it's a kind of a colorful category, this spousal category, because it's gone through, as everything else under the immigration banner, it's gone through enormous changes in the last few years, not the least of which was since 2000, the whole matter of spouses in this era of same-sex marriage and so on. How did the government of Canada handle all that stuff back in the day?
Sure. You were talking about 2002 is when the Act got changed. The Act and regulations, a wholesale change. In the previous law, under the Immigration Act, if you wanted to sponsor your married partner, you could. And it was defined as somebody of an opposite sex with whom you were married.
Right.
And the problem was that people who had same-sex relationships, either abroad or within Canada, weren't defined under the family class. And so immigration, in order to accommodate them, would have to recognize them under humanitarian and compassionate grounds, put them in a whole separate category. So when the government was revamping the law, they said, we've got to accommodate the same-sex situation.
Mm-hmm.
So they came up with the categories of married spouse, common law partner, or conjugal partner. And common law partner is somebody that you live with now, probably in Canada. And you can sponsor them as your partner. You don't need to be married. And a conjugal partner is somebody that you have a relationship with, but they're separated from you by a border. So you're here and they're there. They're in the States somewhere, for instance. And you want to bring them to Canada, but you're not married and you're not common law. And it doesn't say anywhere in the Act that these people are the same sex or the opposite sex.
Right.
It just doesn't say it. The idea was that these categories would accommodate same-sex couples. They didn't want to necessarily define them as opposite or same-sex. It wasn't necessary. Just define them by the terms.
Okay.
And so they passed the law in 2002, and right about at the same time, there were all these changes going constitutionally with whether or not same-sex couples could marry. And various provinces across Canada were adopting marriage of same-sex couples, as well as states and countries around the world. And so now, today, a lot of same-sex couples don't rely upon conjugal partner or common law partner. They get married and get sponsored as married spouses. But yet we still have on the books the common law partner and the conjugal partner. And most of the applicants in there are not same-sex. they're heterosexual.
Right.
So
right.
it's just an interesting history to the category.
The wordsmiths in Ottawa had
Absolutely.
quite a field day with this stuff.
If I may add, the largest group now of conjugal partner applicants are people that are in long-term, long-distance relationships.
Okay.
Who cannot get married for whatever reason, or don't believe in marriage particularly.
Or can't get divorced from a prior
Or
marriage.
can't get divorced from a prior marriage, but can't cohabitate at the same time, but the world sees them as a couple. And the other group are typically people who are quite devout and who don't believe in living together before marriage. And the world, again, sees them as couples. They've maybe even merged their financial affairs and everything else. But the wedding is 2 years off, and it has to be in a certain place at a certain time, and they're not compromising on this. And, you know, those are the situations now where conjugal partner is being used. Quite radically different, as Gordon pointed out, from when it was originally conceived.
What about the situation, again, I'm a Canadian. My company transfers me abroad for a couple of years. While I'm there, I meet a local gal and I fall in love and we get engaged. And then my time is up, I move back to Canada. Can I bring my fiance back to Canada? Because we're going to get married sooner or later, and, you know, we've been together now a couple of years, and this is the real deal. What is the government going to say about that?
You can be. You said you've been together for a couple of years.
Yes, abroad.
Living together.
Abroad.
Living together.
Sure.
Well, then you might be a common law partner.
Oh,
So
okay.
you could be sponsored as a common law partner.
Ah, okay.
But you couldn't be sponsored as a fiance. We don't have fiancés anymore. They got rid of that in 2002.
I see. Okay.
So you would bring your partner over as a visitor, maybe, if
Right.
you were lucky enough to get a visa for them, if they were from a visa-requiring country. But really, you got to get married or make a common law application to bring them in as a family class member.
Okay.
Right.
And when did they eliminate fiancés or intendeds from the list?
2002.
Oh, really?
2002.
Yeah.
Okay.
And
Was that because of abuse, Alex?
It created...
Because you hear a lot about marriages of convenience. You know, I
So-
married some Canadian guy and got over there and we had a Canadian kid and then I dumped him. And, you know, so she's got the legitimate Canadian kid. The guy was, you know, either a dupe or a dope or a really naive person who got taken advantage
Well,
of.
I have to tell you, the main issue was cost and enforcement. So,
Yeah.
Gordon and I in the day actually acted for a lot of people in this situation. What would happen is you would have a fiance would have 90 days to get married once
What's
they
coming
arrived.
hand.
So they became a permanent resident, but their permanent residence was conditional.
Okay.
And the condition was you had to get married within 90 days. And if you didn't get married in 90 days, they could take enforcement action against you. And the way the law was written, this enforcement action was subject to an appeal. The challenge the government had is that there was all kinds of situations. Ones where there was outright marriage fraud, to cases where the applicant was sincere, but the sponsor was not, to other ones where they had a fight on the 5th day that they were here and they ended up getting married just outside of the 90 days. All of those were violations. All of those needed to be enforced. And the cost of the enforcement was simply a deterrent from the government's perspective to keep that program around.
Okay.
They instead tried to go with conjugal partner to either replace it, or they took also. Then the alternative was, from a policy perspective, why are we letting you bring somebody for and then have to get married in 90 days? Just get married before you apply. And that was the thing.
It kind of invited fraud in cases
did.
where there would be fraud.
Right.
So.
Right.
And the enforcement costs, let's face it, they were high, and the government didn't like that for obvious reasons.
Let's talk about processing, and we have a couple of categories that we can use for processing for comparisons. For example, the parent or grandparent category, and then the spousal category. Let's use those two, because the spousal category, this is someone...
Well, let's start with spouses then.
Okay.
All right, then we'll go, because parents are far worse. We'll save that for the second one.
Okay.
But for the spousal category, the processing times are, in my opinion, crazy. Because I think that these kinds of immigration applications are relatively straightforward.
Right.
A Canadian citizen or a permanent resident marries somebody. Maybe they're here in Canada already. They've come as a worker, a student, whatever. They've developed a relationship. They get married.
Right.
And they seek to get sponsored from within Canada, become a permanent resident. Or you're sponsoring them from abroad. You're saying, yeah, we're getting married in Florida next month. I'd like to bring my wife. You know, can I sponsor her, please? We'll just keep her working in the States until the time comes to bring her here.
Right.
In both those situations, the sponsorship times, the processing times are very long. And it is prohibitively long.
And why?
I think it's a resource issue.
Okay.
I think it's purely
just
a
not
resource
enough
issue.
people handling files.
Yeah.
Okay.
And I think to give you an example, let's do a spouse in Canada situation. If you have your spouse in Canada or your common law partner in Canada, you're entitled to file your application here.
Right.
So you file the application and then you wait for permanent residence. And they are taking now, currently, 17 months just to get to the first stage of the application, which is to say this application looks good. Normally at this time we would allow your partner to go get a work permit.
Right.
Until that time they wouldn't be allowed to get a work permit. 17 months, year and a half. Once they reach that point, it's another 10 months until they become a permanent resident. So we're talking more than 2 years.
If it takes a year and a half just to acknowledge the fact that we've received your application and here's an opportunity to get a work permit while we process it, if it takes a year and a half to get to that, what did it used to take?
Well, they used to do these. They used to target it for 6 months processing, start to finish.
Okay. So it's a year. It's overextended by a year now.
Effectively, yes. And the problem largely...
No, a year and a half.
Yeah.
Taking 2 years to get to that point.
Okay.
The problem largely is is absolutely of resourcing. I mean, from the perspective of what needs to be done to make this work, their algorithms in their computer systems are now quite sophisticated. They pick out all kinds of things in advance of when the information is uploaded from a sponsorship application to tell them if the case is high risk for extra scrutiny.
Right.
They look at all kinds of things. Age disparity, is there some huge age difference between the people?
Right.
Previous immigration history. Has the sponsor sponsored 3 wives before this? Has the applicant tried to apply for permanent residence before this? Did the applicant's siblings come through marriage? Are the applicant's siblings in Canada? Is there a huge education disparity between them? Does the Canadian have high school?
Not even huge, significant.
Mm-hmm.
Does the Canadian have high school and the person overseas has a PhD?
Right.
To give you an extreme example,
Mm-hmm.
their systems are very sophisticated now, and these are all disparities based on really good research done in the 2000s on marriage fraud, not just in Canada but worldwide.
Absolutely.
And so a lot of this stuff is automated. So you don't really have you don't have the needs for the same number of officers that you used to have. But unfortunately, the government has taken the resources that were there, moved them around to other parts of the system,
Right.
and not left anywhere near the right amount of resources here. Let me give you an example.
Or they've diminished the resources altogether.
Or they've diminished them altogether. And let me give you an example of that.
All
we
right.
talked on an earlier show about how, in the first stage approval happens in a centralized processing center. The second part is supposed to be done in a local office. Well, there are no local offices in Western Canada outside of the big cities anymore. So if you're in Kelowna or if you're in Victoria, where you used to have an immigration office,
Right.
the file got transferred to you, they called you a few weeks later, you had a scheduled landing interview and became a permanent resident. There are no offices in these places anymore. So instead, there's a rotating officer who goes around the province of British Columbia, same around the province of Alberta, to various cities to arrange for landing interviews, where they rent space from different providers, where they used to have offices.
Right.
So that's a big part of why these things are taking longer and longer.
Right, and one thing that I have learned from all three of you is over time is that the immigration system is just indescribably complex, particularly for the uninitiated. That would be the civilians like me. So how much of an advantage do I gain, if any, in terms of the system by retaining lawyers whose only job it is to understand the system? Does that help accelerate the process at all?
No, your wording is wrong. The idea is correct.
Okay.
All right. There is huge value in getting good advice before you proceed on a marriage application, because there's overseas applications versus inland applications.
Right.
There's lifestyle considerations. There's timelines to understand. There's opportunities for work permits or no work permits.
Yes.
Do you want to be in Canada but not working, etc.? You have to understand those things before you launch into your marriage with perhaps not the right expectations. If you understand what you're getting yourself into, now you can plan your life.
Mm-hmm.
For that, it's a great idea to have consultation, and gee, you need to.
Well, no kidding.
No kidding. And to get back to the spouse in Canada application, just to give you an idea of the kinds of issues involved there, when you do a spouse in Canada application, your spouse is here.
Yeah, she's already here.
So you've gotten married, you've put in the application, and now you realize that they're going to take 17 months to get to the first processing.
Even look at it.
In the meantime, you, the sponsor, are contacting MSP in the province and saying, I want to get my wife onto MSP coverage, please.
Right.
And they're saying, well, yes, you're eligible to put her on because she's an applicant for permanent residence, but we need to have that letter from immigration that says that your application is in process. This is the letter that you don't see for
18 months. Right.
17 months.
Right.
So you would have to deal with the province trying to get them to give you piecemeal coverage while waiting for immigration to catch up to what normally the province wants to see before they would accept you for MSP.
Right.
Now, the government on December 22nd of just the past December 22nd made a change. And what the federal government said is, now for these inland applications, we will give the spouse a work permit within 4 months of the application. Even though it's still taking us 17 months to get to that letter.
Okay.
We'll give you a work permit after 4 months. It'll be a 2-year work permit. This is a pilot project that they've initiated. The only reason they've done that is because it's such a disaster right now.
Right.
In terms of spouses being left high and dry here and unable to access MSP, being unable to work.
Sure.
They're just ruining relationships because of their ridiculously slow timeline for processing.
Right.
So now they're giving out work permits. Now they're going to review that in December of this year, but I think they have no choice but to keep it going.
Now, and I need to take a break, Alex, but just very quickly before we take the break, would lawyers advise, given now that there's this bone being tossed to the long lineup, would a lawyer advise, well, of course, take the work permit and give us something to do for 2 years?
The question becomes, and where our advice is invaluable, is strategy. What are your priorities? Does the spouse want to go to school? Does the spouse want to work? Do they have things that they need to wrap up in their home country?
Right.
What is their most important goal for the next little while?
Lifestyle choices.
Those things are critical for a relationship to be successful.
Definitely.
And quite apart from us providing you with the information that you need to know and what to expect in terms of the processing, we also outline, based on what your goals are and what your strategies are, what makes the most sense for you. That's where the most valuable part of our work is in, because let's face it, these things are very stressful on relationships.
Absolutely.
People go into this not understanding that this is going to take a very long time.
Right.
And often that adds a layer of tension. The applicant maybe believes the sponsor isn't doing everything that the sponsor should be doing.
Right.
Often the applicant doesn't have any experience of Canadian legal culture or Canadian standards or rules. Why aren't you calling somebody? Isn't there someone you can call?
How long is this going to go on?
In my home country, we can do X or Y, and here, you can't really do any of the things that they're used to.
Right.
So educating the client on what to expect and steering them towards what will be the best for their objectives is a key part of our role.
Right.
And just to go back to the example, which I thought was a great example you came up with. I've been overseas. I've married my girlfriend, or she's my fiance.
Right.
I want to bring her back to Canada. If you phoned us up, the questions we would ask are you a Canadian citizen or are you a permanent resident? Because if you're a permanent resident, you have to be residing here before you can sponsor your spouse. If you're a Canadian citizen, you can sponsor from abroad if you show that you intend to come back. All right? Is this going to be an overseas application or is it going to be an inland application? Inland application has access to a work permit after 4 months, but you have to be here. Can we get your partner here, and can you get married here? Is she from a visa requiring country or a non-visa requiring country? Because if she's from a visa requiring country, you got to get through that screen. All right. If she can get here, what are the other access to a work permit? All right. So these are the questions that you need to consider to decide whether or not your emotional plan has any viability.
Right.
Right. Because maybe you need to change your expectations. That's huge.
It's about a solid game plan and strategy, as provided in some cases by my guests in studio. We have Alex Stojcevic and Gordon Maynard. The firm is Maynard Kisher Stojcevic. They are citizenship and immigration lawyers in Vancouver at 1168 Hamilton Street. They have a website. It's vancouverlaw.ca. You might want to have a look at that while we take this quick time out.
There's more of the show still ahead. This is The Law Show on CL 650.